Well, hello, everybody, and welcome back to Raw Law on Time for Once with your host, the DUI guy. Today, we have a very special treat, a stream that I've actually been waiting for several weeks now to do, at least three, because this information has been public for a little bit. But I know Laura B has talked about it on her stream. I don't know anyone else who's been covering it. We're going back to Amber Heard and her insurance kerfuffle, specifically with New York Marine. For those of you who are unfamiliar, New York Marine was one of the insurance companies that Amber Heard has hired and paid for back in 2000, I guess, 18, 19. I forget the date since it's been a short while since I've done a live on this topic. But they're suing Amber Heard, and her insurance, the other insurance, Travelers, are both individually suing New York Marine. So you have two lawsuits, right? We shouldn't do that. Two lawsuits. On the one hand, we have Travelers going after New York Marine. On the other hand, you have Amber going after New York Marine. New York Marine going after Amber as well. It's kind of a back and forth. More like New York Marine going after Amber and Amber filing a counterclaim. This is the one we're going to be talking about today. The New York Marine versus Travelers, Travelers versus New York Marine, we're going to put to the side because today we're focused on this one. Amber Heard versus New York Marine. So what's going on with this case? The plaintiff, New York Marine, is suing defendant Amber Heard because Amber Heard wants to get paid. And New York Marine is saying, we're not paying your costs because your act was intentional. And intentional acts are not covered under the policy. Okay, by the way, don't forget to like this video, comment below, subscribe to the channel, join on as a member. And thank you, Tammy Hoshiyama, for joining on as a member. Hello, chat. Hello, everyone. Hello, hello. Don't forget to smash that like button. So, what exactly is happening this time around, you would think? Well, let me answer. First off, there's a scheduling order in place as of about a month and a half ago. This is very, very important. Judge Wu, United States District Court judge for the Central District of California, where this case is happening, New York Marine versus Amber Heard. There was a telephonic conference that occurred on or about January, end of January. And I tweeted about this. For those of you who are not on my Twitter, you may not be aware of this. But this is what happened. This was the discussion. Court and counsel conferred. We have the following dates. So no more Rule 16 motions. No further amendments are allowed on that. Whatever is in the record is set. A post-mediation status conference. So this case is set for mediation sometime between now and July 31st, or if it's not scheduled yet, will be scheduled between now and July 31st. So post-mediation status conference will be set for August the 3rd this year. Mediation will be completed by July 31st. The parties will make arrangements so that the mediation may be completed by the July 31st date, blah, blah, blah. Everything will be filed with the court on August the 1st. Regular discovery will be completed by August 28th. By completed, that means that said discovery requests must be served sufficiently early such that motions to compel. So if one party refuses to turn over whatever the other party is requesting, you can always ask the court to compel the party to give and fork over what you're looking for. So motion to compel would be an option after that date. Expert discovery to be completed by September 29th. And the last day for the court to hear any motions of any kind, any nature, will be the day before Halloween. which is October 30th, other than motions in limine. Pretrial conference to be held on November 30th, and a jury trial is set for December 12th. Now, what does that mean? Does that mean the case is going to go to trial? Maybe, maybe not. It depends, right? Thank you, Mandu. Appreciate it, brother. Welcome to the channel, man. Hopefully your channel is reinstated by now. I'm very much hoping that you get your channel back. Remember, at last count you had like 11 strikes, right? So it should be almost the end of it. No, LK Nick, you literally joined just in time. You are just in time. We are barely getting started. So saith the judge. Now, is this case going to go to trial? Maybe, maybe not. It all depends on whether or not they can settle, agree. I imagine New York Marine is interested in taking this case to trial. Let me explain why. Insurance policies of all kind, including every single one of your auto insurance policies, states very clearly that in the event that it is discovered that your acts were intentional in any way, shape, or form, the insurance company will not be covering you. So let's say you get into a car accident, you suffer an injury, and you say, ow, I need to go to the doctor, I'm in pain. And insurance says, okay, we'll pay for it. And they pay it out. And then later an investigation comes out that car that struck you, you had an agreement with, that they will be hitting you because they're your buddy and you're paying them half of that settlement proceeds in order to, get them to hit you and blah, blah, blah. Well, that is now an intentional tort. That is now an intentional act. And intentional acts are not covered by insurance policies, and they will come after you to get their money back. Or, as in this case, like New York Marine, they won't pay. They simply will not pay. It's an intentional tort. You don't get coverage. And that's when New York Marine is arguing in the Johnny Depp case. They're saying Amber Heard's conduct was intentional, and as a result of that, they are not covered by the policy, which I think, and again, I think the majority of the world also thinks, is a fairly straightforward, obvious, clear answer. Like New York Marine should win. Amber is saying no. If you have not seen the previous video, go in this playlist that I added this video to, Johnny Depp versus Amber Heard trial appeal and etc. playlist, and you will find the previous video where I talk about, or the previous two videos. I can't remember if I did the Travelers New York Marine or the New York Marine Amber Heard case first, but you'll find it. It's in the playlist. You can't miss it. And that will give you an insight as to what are Amber's counter arguments to that. Okay, so go check it out after you're done with this video. Now, so Amber, of course, in her infinite wisdom, in that video, as I discussed a couple months ago, I think we did it sometime in January. Remember, I told you there's a conference scheduled for like January 13th and all that. Well, this is the beginning. This is the beginning of that court date that they had. See, January 23rd, they had a telephonic conference. Maybe it was the 23rd. I can't remember. It doesn't matter. Here's the point. The point is that after Amber filed her counterclaim against New York Marine saying, I am going to ask you to pay, and here's why, with very, very weak arguments, in my opinion, New York Marine filed a motion to dismiss. And this is what we're going to be going over today. This is the meat of today's live. Okay. So I have these all in order, and we're going to go one by one. There's about 9 filings, maybe 8, and they get progressively more and more interesting as we proceed. And all of these are no older than like 3 weeks. As you can see, this is brand new. I wanted to do it. The Murdaugh trial has prohibited me from being able to cover this. So now you're finally getting the meat, the fun of this Amber Heard insurance stuff. Elkanich, I could never be mad at you. Ever. Thank you for joining. So this is Amber Heard's case against New York Marine, or New York Marine's case. They're the plaintiff, remember. This was filed just short of 3 weeks ago. And for the first time, this is what I've been talking to. This is the title of this video. I am not joking, you guys. There is a court date. There is, for one of the first times in this case, a court date of March 13th, 2023. That's 9 days from today. Today's date is March the 4th. You may be watching the video at a future date, but there is a court date. Is Amber going to be present there in the flesh? Probably not. Probably not. Almost certainly not. Her lawyers will appear on her behalf. So she is going to be there vicariously through her lawyers. And no judge is going to raise ire, like, where is Amber, procure Amber? No. Highly, highly doubtful. But the point is, we have a court date. So see, the case is kind of broken up. Like I keep saying, it's New York Marine versus Amber, Amber versus New York Marine, because she filed a counterclaim. She had the gall, the audacity to say, well, not only am I not paying, or excuse me, I apologize, I misspoke. New York Marine, not only do you think you're not paying, I'm going to make you pay the value of my policy. Plaintiff and counter defendant New York Marine and general insurance companies notice of motion and motion to dismiss her counterclaim. So they're saying, Amber, go away. Shoo, get this counterclaim off of our backs. Get rid of it. It does not belong. I don't know what you're doing. And now we are going to cover what their argument is. So number one, they want a dismissal of Heard's counterclaim pursuant to a 12b6. 12b6 is a failure to state a claim, for those of you unfamiliar with legal lingo. Or alternatively, for a more definitive statement pursuant to Rule 12e. Basically, if the court says, yes, this is enough to survive a 12b6 motion to dismiss for failure to state a claim on which relief may be granted, okay, well, 12e. More definitive statement as to what on earth you're asking us. And 3, to strike certain allegations pursuant to Rule 12F. So right out of the gate, they come out with a baseball bat. New York Marine, that is. To all parties and their counsel, please take note. On March 13th, we're going to be bringing this motion to dismiss 12b6. To dismiss the amended counterclaim filed by defendant Amber Heard in its entirety without leave to amend upon the ground that it fails to state a claim upon which relief may be granted. This is exactly what I just said. Specifically, Heard's allegations, together with both facts of which the judicial notice may be taken and facts set forth in the New York Marine policy, corresponds in other matters referenced in the amended counterclaim, and or upon which the amended counterclaim is predicated, and which may therefore be considered under the incorporation by reference doctrine, yada, 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 show that Heard was defended in the underlying action filed in Virginia, the defamation case of Johnny Depp versus Amber Heard, which he won, and retained counsel from that jurisdiction to defend her, after which, some 6 months later, she tendered to New York Marine, which in turn appointed the same counsel to defend her. Remember, one of the arguments that New York Marine is saying is that we have no obligation to defend you because we assigned you counsel. And not only did you commit an intentional tort, you also did not use the counsel that we gave you. So we're under no obligation to pay for counsel you hired independently. Because one of the precepts of the policy is you must accept the counsel that we give you. Your failure to do so will land you in hot water. Furthermore, Heard's refusal to fully accept the defense proffered by New York Marine under a general reservation of rights, because she found it impossible to do so, do not give rise to an obligation by New York Marine on its part to also appoint independent defense counsel. Furthermore, New York Marine's reservation of rights was general reservation of rights, which does not trigger the right to independent counsel. There it is. This is what I just said. Consequently, Heard's failure to fully accept that proffered defense relieved New York Marine of any further obligation to defend her. In addition, the amended counterclaim fails to allege that any of the defense costs which Heard seeks to recover from New York Marine were incurred at its request, as required by the New York Marine's policy endorsement. Remember the CPL endorsement that we talked about, that there is no voluntary payment provision. Accordingly, her allegations are insufficient to establish New York Marine is liable for breach of contract or even any bad faith. In the alternative, this is argument 2, pursuant to Rule 12E of the Federal Rules of Civil Procedure, New York Marine will and hereby does move this court for an order requiring a more definite statement as to what on earth Amber Heard's allegations are. In paragraph 24 of her amended complaint, she says, quote, I have incurred hundreds of thousands of dollars in defense costs not paid by any insurer, end quote. And that such allegation fails to assert that such costs were incurred either at the request of New York Marine under the policy, or that her incurrence of these costs was not voluntary in violation of the no voluntary payments provision. We don't owe her jack shit, basically, is what they're saying. And why its appointment of counsel previously retained by Heard made it impossible for her to fully accept that defense once New York Marine agreed to defend her. Finally, pursuant to Rule 12F of the Civil Rules, New York Marine will and hereby moves the court for an order striking both the allegations in paragraph 25, asserting the existence of a conflict of interest, and an entitlement. There it is. Entitlement seems to be the ringing word throughout all of Amber Heard's motion. If you've noticed, she's entitled to a defense. She's entitled to payment. She's entitled to choose who she wants to defend her. She's entitled. And 2, the allegations of paragraphs 7 through 16 as immaterial and impertinent in that those statements are self-evidently marketing and puffery, which cannot form the basis of a cause of action as a matter of law. Remember, she argued in her motion that New York Marine advertises themselves as such and such company, promises such and such things, and does such and such. None of that is legal jargon. It's just marketing stuff. It doesn't matter. You can set out to be the number one, best, most amazing, always pays its bills policy. But if you violate a provision of the contract, we don't have to pay. It doesn't matter how, if our track record, we've paid 100% of our policies to date, which they haven't. I'm exaggerating, of course. But to imagine, it doesn't matter, even if they had advertised themselves as like the creme de la creme. They're doing the next best thing, using their own advertisements to try and craft, literally manufacture a legal argument out of non-existence. And I absolutely agree with New York Marine. Not because I dislike Amber, but because the argument makes sense. New York Marine's argument makes sense. Their response is legally cogent, whereas Amber's legal argument is not even an argument at all. It's a logical fallacy that she's committing. It is emotional argument, and emotion has no place in federal practice. The amended counterclaim also fails to allege that plaintiff was contemporaneously aware that any of those statements at the time she purchased the policy, much less that she relied upon them in doing so. They're basically saying like Amber, before purchasing New York Marine's policy, went to their website and did a thorough research and read every nook and cranny and went, wow, this is the best insurance company ever. I want them to be my, that's cute. I like that. It's kind of a completely unnecessary argument, but I like it because it shows the humanity of the situation. And this motion is based on this notice of motion and another motion that is accompanying, which we're about to go through, as well as the request for judicial notice together with exhibits, declaration of James P. Wagner, together with its exhibits, which the court is requested to consider under the incorporation by reference doctrine, and all papers and pleadings, blah, 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 submitted. The motion is made the following, such and such, da, 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 da. Okay. And this is New York Marine's attorneys. James Wagner. One of the attorneys makes an affidavit. We're going to go over it. It's fascinating. It's absolutely fascinating. So More meat. You guys ready for this? Oh, it gets really, really fun. Really, really fun. New York Marine, contemporaneously with what we just read. Again, same date, same heading, as you can see. This is their memorandum of points, the 1, 2, and 3 that we just talked about. It's a motion to dismiss. Since Heard admittedly refused to fully accept the defense, rightfully, by New York Marine, she's not entitled to recover any additional defense costs. We're going to go over that. That's point number 1. Point number 2, because Heard admits that she was defended by travelers, she cannot state any viable claim for the breach of contract or bad faith. You know, it's not a good argument to say, well, they're paying, so should you. That's not an argument. Motion for more definite statement, that's number 3, and a motion to strike, followed by conclusion, etc. So this is some case law. We're not going to go through. Obviously, these are just named cases that they cite. It's easier for judges to follow if they want to reference them. So here it is. Introduction. New York Marine is trying to say that Amber's counterclaim is completely full of it. It's hollow, empty, devoid of legal argument, factually improper, and should be dismissed by the court. Here's why. For 2 principal reasons, claimant Amber Heard claims against New York Marine for breach of contract and bad faith fail to state facts sufficient to constitute claims for relief. First, Heard admittedly refused to fully accept the defense rightfully provided by New York Marine through appointed counsel, the law firm of Cameron McEvoy, PLLC, even though that firm had been retained by her in the underlying action some 6 months earlier and was still actively representing her. Notwithstanding that prior and ongoing relationship, Heard rejected New York Marine's appointment of that firm and instead insisted that she was entitled to be represented by independent counsel. More specifically, her amended counterclaim alleges that she had the right to independent counsel, with New York Marine being obligated. See, powerful words, powerful, obligated to pay for the fees and costs of this independent counsel. Yet New York Marine refused to honor that right, thereby making it impossible for Ms. Heard to fully accept this defense without prejudicing her defense in the underlying lawsuit. This is what she stated in her amended counterclaim. However, says New York Marine, Heard was not entitled to the appointment of independent counsel separate from the firm which she had already retained. Virginia law does not recognize the existence of a tripartite relationship between the insured, the insurer, and insurer-appointed defense counsel under which both insured and insurer are clients of the attorney. Basically, a fancy word for saying you don't get to pick. You don't get to choose. Thus, in Virginia, an attorney appointed by an insurer to defend an insured has only the insured as a client and consequently cannot have a conflict in representing the insured even though they're paid for by the insurer. Further, even if Virginia did recognize a tripartite relationship, nothing in New York Marine's General Reservation of Rights letter created a conflict of interest between her and Cameron McEvoy PLLC so as to trigger any additional duty to provide independent counsel. Additionally and separately, the New York Marine policy only obligates it to pay expenses incurred by the insured at its request. Now, Heard does not allege that any of the amounts she claims she is owed were incurred at New York Marine's request. Further, the New York Marine policy contains a no voluntary payments provision. This is going to become crucial later on, as you will see, stating that the insured will not, except at the insured's own cost, voluntarily make any payment, assume any obligation, or incur any expense other than for first aid to others at the time of the bodily injury, or in this case, financial harm due to the being sued and having incurred a $1 million judgment against her since the mediation settlement, dismissing both appeals. Absent an allegation that Heard incurred the defense costs at New York Marine's request, it necessarily follows that she did so voluntarily. Logical argument. Moreover, and independent of the foregoing, An insured defended by one insurer cannot state viable claims for breach of contract or bad faith against another insurer, which allegedly did not also provide a defense. Now, here, Heard's amended counterclaim alleges that New York Marine agreed to participate in the defense of Ms. Heard by reimbursing Ms. Heard's defending insurer, Travelers Commercial Insurance Company. And since Ms. Heard was separately defended by Travelers, she has no right to also make a claim against New York Marine for failing to defend her. Further, Civil Code 2860C provides that where an insured is defended by an insurer, such as Travelers, through independent counsel, the insurer's obligation to pay fees to the independent counsel selected by the insured is limited to the rates which are actually paid by the insurer to attorneys retained by it in the ordinary course of business, in the defense of similar actions in the community where the claim arose being defended. That's why independent counsel is not permitted under the policy, because let's say the counsel we provide is $300 an hour and you fire them and you hire independent counsel of your own choosing and they turn out to be $600 an hour, where now we're going to be paying double the rate. We're not prepared for that. This is not what we signed up for as the insurer. Okay, that's the difference. That's why New York Marine is one of the reasons they're refusing. As applied by California courts, where two or more insurers each owe a duty to defend, that civil code provides a single rate limitation for a single counsel in defense, albeit multiple insurers may be required to contribute to its payment. It follows that where an insured is defended by an insurer through independent counsel, the insured cannot state a claim for damages against the purportedly non-defending insurer predicated on the theory that it was obligated to pay to independent counsel amounts over and above the hourly rates which the defending insurer was obligated to pay. You see the difference? Therein lies the difference. They're saying, look, you can't have your cake and eat it too, Amber. You chose to hire independent counsel going against our policy. Fine. That's one thing. We get it. Okay. So we are not obligated to pay you right there. But you are going a step further and you're saying, well, these people, Travelers, are paying and so must you as well. And New York Marine is saying, well, you're just giving us the second argument, Amber. Thank you so much. Under the law, we are not obligated to pay you because now you're getting a double benefit from the same, from two different policies. So let's say you're getting $1 from us and $1 from Travelers for a $1 expense. Now you're getting a $2 benefit for a $1 expense, and that is not fair either. We're under no obligation there as well. Relevant factual allegations. General background. Heard was sued for defamation in a civil action filed on March 1st, 2019 in Fairfax, Virginia. This one we're probably going to skim through. There's no reason to read it word by word. First Amendment complaint, So originally, she retained the Virginia law firm of Cameron McEvoy to defend her, and they first made an appearance on March 19th. Now, more than 6 months later, Heard belatedly tendered her defense in the underlying action to New York Marine on September 4th. Following her untimely tender, New York Marine timely accepted that tender on October 1st, subject to a general reservation of rights, which stated, to the extent California law does not permit an insured to indemnify the insured, no indemnity can be provided. Upon accepting Heard's tendered defense, New York Marine appointed as her defense counsel the Cameron McEvoy firm and attorneys Timothy McEvoy and Sean Roche, the same firm and the same attorneys which she had already retained some 6 months earlier. Nonetheless, and we know obviously those are not the lawyers that represented her, nonetheless, Heard's amended counterclaim, which acknowledges that Travelers was her defending insurer, further alleges that because it was impossible for her to fully accept the defense provided by New York Marine through the Cameron McEvoy firm. Now, the policy says, New York Marine's policy says, the comprehensive personal liability coverage, the CPL endorsement states, if a claim is made or a suit is brought against any insured, we will provide a defense at our expense by counsel of our choice. At additional coverages, it states that we cover the following in addition to the limits of liability. Claim expenses will pay reasonable expenses incurred at an insured at our request, at our request, at our request. The ones that we choose, not you. Up to $100 per day for assisting us in the investigation or defense of a counterclaim or suit. Conditions, duties after loss. The endorsement further states that, quote, in case of an accident or occurrence, in which case this is an occurrence, the insured will perform the following duties that apply. The insured will not, except at the insured's own cost, voluntarily make any payment, assume any obligation, such as hiring new counsel, or incur any expense other than for first aid to others. It further states as relevant under 6 suit against us that no action shall be brought against us unless there's been a compliance with the policy provisions. Now, that one is a little loose. It's basically limiting your access to the courts. If you're failing to comply with the policy, you can't sue us. It's a bit of a stretch, but hey, it's still an argument. So they're making it. That's why it's dead last, because it's the weakest. Everything else holds a lot of merit and has a lot of value. So they're filing a motion to dismiss. Dismissal of a counterclaim under 12b-6 is allowed if it is warranted, if a claim or counterclaim fails to assert either, quote, a cognizable legal theory or the absence of sufficient facts alleged under a cognizable legal theory. We're not going to go through the legal standard for it because that's irrelevant. But essentially, under the doctrine, a plaintiff's claims are predicated on a document and the defendant must allege certain facts and legal theory to survive a motion 12b-6. Okay? In addition, a court may judicially notice a fact that is not subject to reasonable dispute, and that is also attached to this motion, as you will see. Since Heard admittedly refused to fully accept the defense rightfully provided by New York Marine, she's not entitled to recover any additional defense costs from New York Marine. A policy provision giving an insured the right to appoint defense counsel requires that the insured accept that appointment, and she failed to do so. Here's how. Where an insurer's policy, as does the New York Marine policy here, imposes upon it the duty to defend and gives it the right to appoint counsel, which she did, the insured's refusal to accept that defense relieves the insurer of the obligation to pay the insured's defense costs. Now, let me read that again because it is so important. Where an insurer's policy, like New York Marine's here, has a duty, which they did, to defend, which they did, and gives it the right to appoint counsel, which it did, Amber's refusal to accept the defense relieves New York Marine's obligation to pay for Amber's defense costs. Crystal. And they're signing a law, Sargent versus Johnson, that says the insureds, every time you see the word insureds, that's Amber. Every time you see the word insurer, that's New York Marine, or possibly travelers, depending on who they're talking to. Look at who insurer modifies to make sure you're not missing an important fact. Might as well just call Amber, for simplicity's sake. Amber's conduct in discharging defense counsel, well, in that case, it is the insured's. This is referencing Sargent v. Johnson. So the insured's conduct in Sargent v. Johnson in discharging defense counsel provided by the insurance carrier in that case constituted a violation of terms of the existing policies and relieved the insurer of its duties. Boom. Next case, Twin City Fire versus Ben Arnold Sunbelt Beverage Company. of South Carolina. The insured's wrongful refusal of insurer's proffered defense through appointed counsel relieved the insurer of all liability for defense costs. Didn't have to pay. Reynolds versus Maramoros, stating that the insured may refuse the legal representatives proffered to him by the carrier, but that it may result in a breach of the contract and consequently relieve the carrier of its responsibility under the policy. And one more, Miniman versus Farmers Insurance Exchange, a California case. Insured's decision to reject appointed counsel and go forward was done at its own risk. Thus, an insured who erroneously refuses to accept a defense through counsel rightfully appointed by the insurer based on the mistaken belief that they're entitled to independent counsel. Again, mistaken belief. Amber thought she could, but she couldn't. Policy of New York Marine, which she signed up for, does not allow this. Cannot recover any resulting defense costs which they incur in doing so. For example, Federal Insurance Company versus MBL. The insured MBL tendered its defense to several insurers, each of which, including Federal, extended a defense subject to a general reservation of rights, kind of like the case here. However, MBL refused to allow the insurer's appointed counsel to associate as defense counsel, asserting it was entitled to independent counsel of its own choosing, pursuant to Civil Code 2860. After MBL defended itself through counsel which it selected, one insurer, Great American, reimbursed MBL. Wow, this is looking almost exactly like our case. No wonder that they're talking about it. They reimbursed MBL for its defense costs, while the remaining insurers, which also had duties to defend and rights to do so through their own appointed counsel and had offered to do so, refused to either pay the cost of the insured separately retained independent counsel or to reimburse Great American for an equitable share of its costs for paying the insured's independent counsel. MBL and Great American in turn brought suit against the insurers, which declined to fund MBL's defense via independent counsel, asserting various claims, including as relevant a claim for equitable contribution by Great American. In granting summary judgment in favor of the insurers, which did not agree to defend through independent counsel, the court observed that none of the insurers disputed their duty to defend, that their general reservation of rights did not trigger the insured's right to independent counsel, but that MBL, however, insisted on retaining independent counsel rather than allowing counsel appointed by the insurers to conduct the defense. Literally the exact case that we have here, only instead of a collection of insurance companies, we just have one, Travelers, which paid. Or excuse me, well, one which paid, just like here, and then instead of a collection, we have New York Marine, which is refusing to pay. Accordingly, the court concluded that MBL was not entitled to independent counsel, and basically saying, court, you should find the same here. That the trial court properly granted the insurer's summary judgment motion against MBL, and that none of the insurers, including Great American, were ever obligated to reimburse MBL for the fees generated by that counsel. That's crucial to New York Marine's argument. For example, another case says there was no conflict of interest between Russo's and Allstate that required it to fund an attorney of her choosing. Her failure to do so negated Allstate's obligations. As you can see, the case is very clear-cut. Again, very clear-cut, very direct, very on point. There's a lot of supporting case law, a lot of cases that are almost exactly verbatim like the case here. So this is not a novel issue. This is not a new issue. The court, the federal court in Central District of California does not have to pave new stones and create buildings out of clay. They can literally, the buildings are already standing. They just have to look at them and go, yeah, this is kind of like, this building is kind of like this building. You know, that case, this case is kind of like those cases over there, and rule in the same fashion. So New York Marine definitely has the force of law supporting its arguments. Amber's, not so much, as you all can see. If you don't believe me, when you're done with this video, go check out the previous video that I did in this same playlist where I talk about Amber's counterclaim. It is ridiculous. It is absolutely ridiculous. Where the insured refused defense through appointed counsel and demanded independent counsel, which is exactly what Amber did here, by the way, which the insurer was not obligated to provide, just as New York Marine didn't. The insurer had no obligation to relinquish its defense of the insured or to permit the insured to utilize independent counsel at its expense. Now, tying it to our case, Amber Heard's allegation that she did not fully accept the defense proffered by New York Marine because it was impossible, quote unquote, for her to do so does not alter this analysis. A defense proffered by an insurer is not logically divisible in any way. Further, California law is clear that an insured cannot partially accept an insurer's offer of a defense under a reservation of rights. Rather, the insurer's offer of a defense subject to a reservation of rights only permits the insurer to decide whether to accept the insurer's terms for providing a defense or instead to assume and control its own defense. Consequently, Heard's amended counterclaim is barred by the New York Marine CPL endorsement's no action clause. For example, where the insurer has fulfilled its contractual obligation in the case of Prurian versus Agricultural Insurance Company to provide a defense of the underlying action, the standard no action clause will preclude any recovery by the insured. And in Safeco versus Superior Court, the no action clause gives the insurer the right to control the defense of the claim, to decide whether to settle or to adjudicate the claim on its merits. When the insurer provides a defense to its insured, the insured has no right to interfere with the insurer's control of the defense. Argument number 2 under this clause. Since under Virginia law, insurer-appointed defense counsel has only the insured as a client, Heard was not entitled to independent counsel and was therefore not entitled to reject defense proffered by New York Marine. Now, here things are going to get a little bit complicated. Under California law, so the insurer-appointed defense counsel in Virginia only represents the insured and consequently no conflict of interest exists. Under California law, an insurer's duty to defend requires that it pay for counsel selected and controlled by the insured. Independent or cumulus counsel only where an actual conflict of interest exists between the insured and counsel and the insurer. So you don't have a right to pick unless there's a conflict, bottom line. Here, since Heard was sued in Virginia, and with respect to New York Marine's contractual obligations under its policy, Civil Code Section 1646 is the choice of law rule that determines the law governing the interpretation of a contract. The section provides that a contract is to be interpreted according to the law and usage of the place where it is to be performed. So we're not analyzing this contract between Heard and New York Marine under California law. We're examining it under Virginia law. Or if it does not indicate place of performance according to the law and usage or the place where it was made, which would be California. Amber had to be represented by an attorney licensed to practice law in Virginia courts. Here, the New York Marine policy was issued in California to a California resident who was then sued in an action venued in Virginia. A liability insurer's duty includes both defense and indemnity obligations, with the defense obligation entailing the rendering of a service vis-a-vis the mounting of and founding of a defense. The insurer performs its defense obligation by providing defense services through an attorney in the jurisdiction where the suit is prosecuted. Thus, Virginia is the place of performance. So California is the place where they make the contract. Virginia is the place where the contract is executed. Simple, right? When you put it that way, DUI guy, yes, it seems a lot simpler. Thus, Virginia is the place of performance. 1646 choice of law test, as interpreted by Frontier Oil, applied to a duty to defend dispute to an action venued in Orange County under the policy issued in Oregon. This is a direct example. Now, as I said, Amber was represented by attorneys licensed to practice law in Virginia. And Virginia Superior Court rule such and such prohibits non-lawyers from practicing in Virginia unless they are licensed there under a pro hac vici, basically. So, unlike California law, For two reasons. Virginia law does not require liability insurers which defend their insured under reservation of rights to provide independent counsel. Sound familiar? First, under the Virginia Code of Professional Responsibility, insurer-appointed defense counsel only has the insured for a client. Second, Virginia law, unlike California law, does not impose any legal presumption that defense counsel retained by an insured to defend an insured under reservation of rights will do anything in the conduct of that defense which is inconsistent with the insured's interests. In this one case, Jordan Coyne Savitz, LLP, a liability insurer brought a legal malpractice action against a law firm which it had previously retained to defend one of its insured in a personal injury lawsuit. In its complaint, the insurer alleged that it was the client of an attorney whom it retained to defend its insured, since it had selected, retained, and paid defense counsel to undertake the insured's representation. Though acknowledging that some states, including California, do recognize the tripartite relationship under which the insurer retained defense counsel represents both the insured and the insurer, the Jordan court, in granting the law firm's motion to dismiss, noted that the Supreme Court of Virginia has never suggested that an insurer, as well as the insured, may be a client of the law firm the insurer retains to defend an insured. Makes sense, right? Instead, the court looked to Virginia State Bar ethics opinions approved by the Supreme Court of Virginia, which makes unmistakably clear that an insurer is not the client of counsel it retains to defend an insured. Virginia state courts have similarly so concluded. In Opinion 598, the legal question presented was whether Virginia Code of Professional Responsibility prohibits representation of an insured by a staff attorney for a liability carrier, and concluding such representations are permitted, it relied upon another Code of Professional Responsibility that says a lawyer shall not permit a person who recommends, employs, or pays to render legal services for another to direct or regulate their professional judgment in rendering the services. Otherwise, they become a non-client at that point. As a result, it concluded the lawyer so employed shall represent the insured as their client with undivided fidelity. You cannot diverge. The client of an insurance carrier's employee attorney is the insured, not the insurance carrier. Let me read that again. The client of an insurance carrier's employee attorney is the insured, not the carrier. So Amber, not New York Marine, in simple terms. So under Virginia law, New York Marine's retained counsel did not have a conflict of interest in the representation of Heard, and New York Marine had no separate obligation to also provide independent counsel. Because if there had been a conflict, that would make a whole lot of sense, right? If counsel had a conflict with Amber, so New York Marine says, we're going to send Bob to represent you, Amber. And Amber goes, I have a conflict with Bob. I can't have Bob represent me. Bob represented my husband in the divorce. I'm conflicted out. And New York Marine says, well, we don't care. Okay. That would be a simple example where there's a direct conflict. And because Bob cannot represent Amber Heard because Bob represented Johnny Depp in the divorce proceedings, well, now New York Marine is on the hook. Amber goes out, finds independent counsel and says, Joe is going to represent me, and fires Bob. And then New York Marine says, well, we're not paying. You didn't use Bob. You used Joe. Well, the courts will disagree. Courts will say, no, Bob had a direct conflict with Amber, and so Bob could not represent Amber. Amber had to go and hire Joe, and now you, New York Marine, are under an obligation to pay Joe's expenses because you elected Bob, who Amber had a conflict with. Does that make sense? I'm trying to make it as simple as I can because I told you guys, this stuff gets hairy. It is not easy, even for an attorney sometimes to understand. We're in the weeds. We're in the weeds, ladies and gentlemen. We're in the weeds. So I'm trying to make this as clear as I can. As noted, following the initiation of the underlying action, Heard admittedly retained the Virginia law firm of Kevin McEvoy and licensed attorneys McEvoy and Roche to provide her defense, or Roche. Okay, all right. Good. Thank you, Denise. Thus, when her defense was first tendered to New York Marine some 6 months later, and it accepted that defense, nothing changed, either analytically, ethically, practically, etc. Mr. McEvoy and Roche and their whole firm had only Ms. Heard as their client. Applying these fundamental legal principles, no conflict could exist between the Cameron McEvoy firm and its attorneys on the one hand and Heard on the other. Because, as this court has previously concluded under Virginia law, the Cameron McEvoy firm and its attorneys would never be in the position of having to choose which master to serve. Furthermore, neither the Cameron McEvoy firm or any of its attorneys were ever subject to the California rules of professional responsibility because they're Virginia lawyers, and the amended counterclaim does not allege otherwise since the underlying action was pending in Virginia, case in point, and its attorneys who represented Heard were only licensed to practice law in the courts of Virginia and several other eastern states. Third, since New York Marine's general reservation of rights letter did not give rise to a conflict of interest, Heard was not entitled to the appointment of independent counsel. And under California law, an insurer may unilaterally and without breaching its obligation to defend, extend the defense to an insured subject to a unilateral reservation of rights, kind of like what New York Marine did in this case. Stating of an insurer's reservation of rights that because the right of the insurer alone, it may be reserved unilaterally. You don't have to have an agreement from the other side because it's a reservation of rights. Indeed, the California Supreme Court observed in both Buss and Jacobson through reservation, the insurer gives the insured notice of how it will, or at least may, proceed and thereby provides it an opportunity to take any steps that it may deem reasonable or necessary in response, including whether to accept defense at the insurer's hands and under the insurer's control, or instead to defend itself as it chooses. If an insured accepts such a defense, they are deemed to have accepted this condition. New York Marine's October 1st, 2019 reservation of rights letter, which the court is entitled to consider pursuant to the incorporation by reference doctrine, only generally reserved its rights while stating that to the extent California law does not permit an insurer to indemnify the insured, no indemnity can be provided. And the Wagner Declaration will say that which we'll review in just a moment. Such a letter is deemed a general reservation of rights letter. Such a general reservation of rights letters do not create a conflict of interest between the insured and the insurer, extending a defense subject to such reservation, cited by a bunch of cases that follow the exact same principle. Rather, as the court in MBL observed, general reservations are just that, general reservations. At most, they create a theoretical potential conflict of interest, nothing more. However, under California law, only an actual conflict of interest triggers an insured's right to independent counsel. A mere possibility of an unspecified conflict does not require independent counsel. The conflict must be significant, not merely theoretical, actual, not merely potential. That's MBL. Consequently, New York Marine's general reservation of rights letter did not create an actual conflict, nor did it trigger a right to independent counsel. Civil Code 3513 states as relevant that a law established for a public reason cannot be contravened by private agreement. In turn, the statutory preclusion against an indemnification of willful acts set forth in Insurance Code 533 reflects the public policy of the state of California to discourage willful torts. So we don't want to encourage people to go out and hit other people intentionally in the anticipation that insurance will simply pay the bill. We only pay for negligent conducts. Insurance and courts that do insurance cases and render insurance decisions are not interested in creating a litany of litigation and litany of cases where insureds are simply chasing insurance companies for money they don't rightfully deserve, which makes logical sense when you really think about it. It's not a surprise, like in the car accident example that I gave of you getting hit by your best friend in order to collect insurance money for your injuries. That would be an intentional tort and thereby not legally binding for the insurance company to pay up. Makes sense, right? Again, it's all very, very straightforward. There are really no surprises here so far, as you all can see. And Heard was not entitled to recover expenses incurred by her in the absence of an allegation that such expenses were incurred at New York Marine's request. Because New York Marine never requested her to hire independent counsel, Rottenborn and Elaine Bredehoft. They gave her counsel, Roche and that other guy. And they said, go, Amber, go forth and prosper. And she goes, I'm hiring these guys. All right, that's on you now, Amber. The New York Marine Policies CPL endorsement states that New York Marine will pay reasonable expenses incurred by an insured at our request. Absent such a request, which was never made, or an allegation thereof, an insured is not entitled to recover their expenses incurred. An insured which fails to provide evidence of an insurer's request to the insured to incur costs fails to establish if these additional expenses are covered by the insurance policy. For example, an insurer's initiation of an action against an insured did not entitle the insured to recover expenses incurred in defending where such expenses were not incurred at insurer's implied request. There is no allegation in Heard's amended counterclaim that any of the defense costs which she seeks to recover from New York Marine were incurred at its request, clearly, because New York Marine never requested them. Allegation of Heard's amended counterclaim admitting that she refused to, quote, fully accept the defense provided by New York Marine, end quote, literally admitting she didn't. It was impossible for her to do so, which is complete bogus, does not amount to an allegation that any of the amounts for which she seeks recovery from New York Marine were incurred at New York Marine's request. Consequently, Heard's amended counterclaim fails to allege facts sufficient to establish her entitlement to recovery of any of her alleged defense costs from New York Marine. Fifth, Heard's refusal, stop and opine, many do not understand. Sorry, I thought I keep pausing. I keep pausing and explaining. Well, let me at least finish this section so people. That's why I hold on. I'm lost as to how chat is lost because look, I did say it's complicated, but every time I finish a paragraph, I try to kind of summarize it to make sure that everyone is on the same page. By the way, so I hope everyone is following along because for the most part, it's really simple. It really is. I can literally sum up the last 25 pages in one sentence. Amber hired independent counsel. New York Marine did not approve. Therefore, New York Marine does not have to pay Amber. That's it. That's literally all they're talking about. Remember, I said we are in the weeds. We are in the weeds. They have to lay out the entire argument. They have to go back. They have to cite case law. They have to substantiate their claims. They can't just say like, well, we don't have to pay because policy says so. They have to explain why. They have to go into the weeds. They have to go deep. So I'm trying to like explain as to every few paragraphs when it gets confusing, and I hope I'm making sense. So I'm sorry if it's not, Corey, but it looks like people are disagreeing with you in the chat as I'm reading the chat. Don't feel bad. It's just you, bud. No, I'm just kidding. I love you, Corey. And thank you for the gentleman's bet, by the way. Yes, I go burn my own home. They will not cover it. Exactly, Corey. I know this is a previous comment, but I did want to make sure I highlighted it. You look Andy's clip. Did you see Andy's clip with her ties to Rolling Stone? I have not, Rio. Oh, baby. I have not seen that. Well, Lori, we don't know yet. Lori says many, very many, are a tad confused as to who will get stuck paying. Hopefully Amber Heard will, but that as yet doesn't appear a possibility. Well, we don't know. Remember, what we're going over right now is an active, pending, unresolved, we don't know the answer, we don't know a decision because we don't have a decision case. This is an active case that has a court date as the title below, as you're looking at this video, unless I changed it. The title of this video is Amber Heard's court date to hear this motion for dismiss Amber's counterclaim is set for March 13th, 2023. Today is March 4th, 2023. So we're 9 days away from possibly having the court determine whether or not Amber Heard's counterclaim that, yes, you should dismiss your claim, New York Marine, and pay up, is going to be dismissed or not by the court, or it's going to be allowed to move forward. Now, New York Marine's lawsuit against Amber to lay off and stop asking for the money is going to be alive and well, but the counterclaim argument is going to be decided in 9 days on Monday, May 13th, lucky number 13. Okay? Are we all on the same page? I don't think they'll do it either, Carrie. I think the court will dismiss the counterclaim, but you never know. You never know. The law seems to be on New York Marine's side through and through, like unapologetically, very directly, very purely. The question is, how is the judge going to do? Judge Wu is going to be the ultimate decision maker. Okay, so let's get back into it. Heard's refusal to fully accept the defense proffered by New York Marine had the effect of breaching her obligations under the New York Marine policy. The endorsement also contains a provision colloquially known as a no voluntary payments provision, which states that the insured will not, except at the insured's own cost, voluntarily make any payment, assume any obligation, or incur any expense. This is you don't get to make your own independent decisions without letting New York Marine know, Amber. Amber, you need to let New York Marine know what you're doing so that we're aware, and then we either acquiesce, meaning say yes to your conduct and we'll continue to pay, or we say no and we don't pay. That's why that's important. Otherwise, Amber could have done whatever she wanted and then New York Marine would be on the hook for it, which is not fair. Truck Insurance Exchange versus Unigard Insurance observed the entire purpose of such no voluntary payment provisions is based on the equitable rule. It's equity, that the insurer is vested with the complete control and direction of the defense, not the insured. New York Marine gets to decide, not Amber, because New York Marine is the one fronting the bill. It's the one who's paying the bill that gets to call the shots. I mean, think about it. Doesn't it make complete and obvious sense? Where a policy includes such a no voluntary payment provision, California courts have consistently held that it is only when the insured has requested and been denied a defense by the insurer that the insured may ignore the policy's provision forbidding the incurring of defense costs without the insurer's prior consent, which did not happen in this case. Thus, in Haskins, the insured tendered their defense to Wausau, which responded that it was investigating the claim subject to a reservation of rights and subsequently that it was prepared to engage in settlement discussions with the third party. The insured, nevertheless, rejected a proposed settlement negotiated by Wausau, took the position that it had failed to defend, asserted the right to assume its own defense, and thereafter negotiated a new and different settlement which purported to bind Wausau. In the subsequent suit by the insured against Wausau, the court granted Wausau's motion for summary judgment, which dismisses the case, since the policy's no voluntary payments provision, citing the policy's no voluntary payments provision and observing that Wausau did not deny plaintiff's request for a defense, it undertook the defense and successfully resolved the claim. Therefore, plaintiffs were not free to undertake their own defense at Wausau's expense. Doing so was a violation of the terms of the policy with Wausau. The court then held that the insured had breached the cooperation and no voluntary payments provisions of the policies, and therefore the insured assumed the costs of their own defense. Logical. Other courts applying California law have likewise concluded that an insured's post-tender breach of a no voluntary payments provision excuses the insurer from being obligated to reimburse the insured for such expenses. Furthermore, such no voluntary payments provisions are enforceable by the insurer without any showing that the insured's payments of an expense or an assumption of an obligation without its consent caused the insurer prejudice. A breach of no voluntary payment provisions, said one case, does not require a showing of prejudice. Another case stated that the Ninth Circuit is unaware of any California authority, that's where California is in the Ninth Circuit, that imposes a prejudice requirement for enforcement of a provision in the no voluntary payments provision. Consequently, this court In this case now, we're saying the court should conclude that Amber Heard's admission that she failed, that she admitted to this in her counterclaim, that Amber failed to fully accept the defense that was offered to her by New York Marine and thereby incurred some defense cost, as we clearly know, because she had to pay, coupled with the absence of an allegation that such expenses were incurred at New York Marine's request and not voluntarily independently establishes a breach of the no policies, no voluntary payments provision. Heard's express admission that she refused to fully accept the defense which New York Marine offered and her related failure to allege. Notice how they're saying this phrase, fully accept the defense. They said it at least 7 or 8 times already in this motion, and there's a reason for that. Because that is literally shooting herself in the foot directly. That is why they keep quoting the same language over and over. She's like, of course, I failed to fully accept. I failed to fully accept. I failed to fully accept because it was impossible for me to do so. That's not an argument. And you are in violation of the policy. You did what you did. Facts are facts. You can't turn back the clock. You can't say, all right, never mind. Let's mulligan, do the Johnny Depp trial again, and I'll be represented by you guys. Come on. Ship has sailed. Train has left the station. The worm, bird, underground. I don't know. Use your analogy. And her related failure to allege that amounts she incurred were either incurred at New York Marine's request, notwithstanding the no voluntary payments provision, overcomes the inconsistent general boilerplate allegation that she complied with all other conditions contained in the policy. But come on, you're contradicting yourself, Amber. General allegations that defendants engaged in fraudulent conduct overcome by specific allegations that the other parties had committed the actual alleged fraudulent conduct. In another case, in the context of contract claims under California law, California courts have consistently held that general allegations like those in plaintiff's FAC are insufficient. In general, specific allegations control general allegations. Number 6, and finally, as to point number 1, Heard's allegations are insufficient to establish that New York Marine is liable for breach of contract or bad faith, which was another argument that Amber made in her counterclaim. Remember, again, this is New York Marine responding to Amber's counterclaim to New York Marine's lawsuit. It's a chain. It's always a chain with these legal cases. It's never direct, clear cut. Tammy asks, this is a very viable question. Did Amber Heard retain independent counsel because New York Marine's appointed counsel wouldn't file Amber Heard's counterclaim? It's possible. See, I don't know. I couldn't tell you because I don't know why she fired them and hired Ben Rottenborn and Elaine Bredehoft's firm. But there was obviously a reason. Maybe someone else in the chat knows. Feel free to chime in. Finally, under the well-established legal principles applied by California courts, since New York Marine's policy authorized it to appoint counsel and it did not have a duty to provide independent counsel, it did not breach any duties which it owed to Heard under the policy by refusing to provide independent counsel. In turn, under California law, without a breach of the insurance contract, there can be no breach of the implied covenant of good faith and fair dealing. Therefore, Amber Heard can have no viable claims for either breach of contract or bad faith predicated upon New York Marine's refusal to provide her with independent counsel or to recover defense costs allegedly incurred by her on account of her refusal to fully accept the defense provided by New York Marine. Let's go to argument number 2. Because Amber Heard admits that she was defended by travelers, she cannot state any viable claim for the breach of contract or bad faith against New York Marine. Travelers is travelers, New York Marine is New York Marine. Separate and apart from the foregoing, Because Heard admits that she was defended by Travelers, she cannot state any viable claim for breach of contract or bad faith against New York Marine. An insured is only entitled to one full defense. You don't get to have your cake and eat it too. Remember? Again. Furthermore, as the court explained in San Gabriel case, the hourly rate limit of Civil Code such and such, which limits the defending insurer's obligation to pay the rates which are actually paid by the insurer to attorneys retained by it in the ordinary course of business in the defense of similar actions in the community, provides a single rate limitation for a single counsel and defense, albeit multiple insurers may be required to contribute to its payment. So if the lawyer charges $1 an hour, just to make it simple numbers, and Travelers has been paying $1 an hour, Amber cannot come to New York Marine and say, well, you also owe me $1 an hour. Because now you're recovering $2 an hour for the payment of $1 an hour. You're getting double the benefit. That doesn't work. The only thing she can do is allow Travelers to go after New York Marine, which is also happening, and saying, look, I paid $1, you owe me 50 cents, because 50 cents is what I'm responsible for, because I was one of the insurers of the insured, Amber, and now you owe 50% because you're the other insurer. If there were 3, it would be 33 cents a piece. If there were 4, it would be 25 cents a piece, and so on and so forth. Make sense? As a result, where one insurer provides a full defense to which the insured is entitled, the insured has no further entitlement to a defense from other insurers, since under such circumstances, the insured is not faced with an undue financial burden or deprived of the expertise and resources available to insurance carriers in making prompt and competent investigations as to the merits of lawsuits filed against their insureds. In trade winds, no damages, and so no cause of action was allowed, where other insurers were on the risk and assumed the insured's defense. So basically, Amber, by having 2 insurers, kind of screwed Travelers over, because Travelers has been paying, and now Travelers may just be on the hook themselves. So this does answer one question, kind of, sort of. Let's assume New York Marine wins, okay? If New York Marine wins and they're completely out of the picture, Travelers will be on the hook to pay the $1 million to Johnny, which Johnny is going to give to charity. All right, here's the final tie-in that you all have been waiting for. I'm just gonna throw it out there because I think this is a burning question on everyone's minds. So Johnny is owed $1 million pursuant to the settlement because Amber Heard settled in order to avoid losing the appeal and having to pay $15 million or 10.35, whatever it was, 10.350. So in order to pay the $1 million, because she has insurance to pay it for her, Travelers and New York Marine are battling it out. Is Travelers going to have to pay $500,000? New York Marine's going to have to pay $500,000, and plus all the defense, the other bills on the back end? Or is Travelers going to be on the hook for the $1 million and all of the defense costs to the attorneys? Or if they're already paid out, is New York Marine going to have to come back and chip in 50%? That's basically the question that is being asked. Everything else is already resolved. The jury trial is over. Johnny won. The appeal is over. Johnny won a second time. He got less money, but he doesn't care. He's giving it all to charity. It wasn't about money to him. It was about reputation. His reputation has been completely restored. And so the only thing left is this. Now, in the alternative, New York Marine is asking for a motion for a more definite statement. Whatever you did, Amber, does not make sense in the eyes of the law. So if you don't lose simply on the basis that whatever you said fails to state a claim upon which relief may be granted by the court in the Central District of California, you at least have to clarify what the heck you are asking us to do. As noted above, the amended counterclaim alleges that Heard found it impossible to fully accept the defense provided by New York Marine. To the extent that the court does not dismiss without leave to amend and finds that paragraph 25 does not amount to a clear-cut admission that Heard either refused to accept the defense provided by New York Marine or that she interfered with its right to control or defense, well, then New York Marine moves in the alternative that the court order that she provide a more definite statement as to what aspect of logically indivisible defense proffered by New York Marine did she not fully accept. Please clarify, Amber. New York Marine does not understand what you're asking. You're confusing us. Motion for a more definite statement is permitted under Rule 12e, where a pleading is so vague and ambiguous that the party, in this case New York Marine, just cannot reasonably prepare a response. Please explain. We don't understand what you're asking. Furthermore, Heard should be obligated to explain whether her claim for defense costs includes post-tender attorney's fees subject to the limitations of Civil Code such and such, and whether any of her incurred defense costs not paid by an insurer were incurred at New York Marine's request. Very, very important. And third, motion to strike. Rule 12F provides that the court may strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. As it relates to a 12F motion, immaterial matter in that which has no essential or important relationship to the claim for relief or the defense is being pled. Likewise, impertinent matter consists of statements that do not pertain and are not necessary to the issues in question. The purpose of a 12F motion to strike is to avoid the expenditure of time and money that must arise from litigating spurious issues by dispensing with those issues prior to the trial. So first, what should we strike? This is what New York Marine is asking the court to strike. Number one, the amended counterclaim's independent counsel allegations should be stricken. To the extent that the court does not agree that Heard's amended counterclaim should be dismissed without leave. So remember, it's a hierarchical structure. First, dismissed it entirely. Failure to state her claim upon which relief may be granted. She admitted, she hired her own counsel, we're not obligated to pay, just dismiss the counterclaim court. If the court goes, boom, we agree, we don't go to number 2 or number 3 at all. If the court says, well, I disagree, the claim should move forward under number 1. Well, and then number 2 is please clarify. If the court agrees, okay, I agree. You should clarify. I don't understand this either. Then number 2 goes. Or if number 1 and number 2 fail, then we go to number 3. We should strike certain arguments from the record. On the grounds, the court should strike the allegation of paragraph 25 that New York Marine reserved rights to deny any coverage on the ground that Ms. Heard behaved intentionally. Remember, intentional conduct is not covered by insurance policies. Thus creating a conflict of interest with Ms. Heard and giving Ms. Heard the right to independent counsel, with New York Marine being obligated to pay for the fees and costs of this independent counsel. In this respect, since New York Marine's general reservation of rights did not reserve rights to deny coverage on the grounds that Ms. Heard acted intentionally and consequently did not give rise to a right of independent counsel, that allegation is nevertheless immaterial and impertinent with respect to her claims. Number 2. Paragraphs 7 through 16 of the amended counterclaim should also be stricken as immaterial and impertinent. Those paragraphs quote website statements. Remember, she was trying to argue that your website says that they are a pro-side specialty and co-action specialty. Those allegations are immaterial for 2 reasons. 1, statements are plainly marketing materials. They're not relevant. They're not even admissible as peril means sideline, evidence, where they may assist in ascertaining the party's reasonable expectations with respect to the interpretation of an ambiguous policy provision. Here, however, the amended counterclaim does not allege that any terms of the New York Marine policy or the endorsement thereto are ambiguous. And secondly, it is apparent from their face that the statements by pro-side and co-action of the complaint, of the amended counterclaim are puffery and marketing puffery, which are not actionable as representations or promises. Like Allstate's advertising slogan in the Smith case, that its insurers were, "Are you in good hands?" Remember that? That they were in good hands did not provide a basis for a fraud or misrepresentation claim as a matter of law. You cannot use advertising material puffery language that advertisers use in their, that companies use in their advertisings as an argument in court. Those are two completely different things. It's almost like these people are on another planet sometimes, I don't get it. Hi, Larry. You look great. Sent you something. Thank you. Beautifully damaged. I'll check it out. Moreover, even if Heard was attempting to allege some form of fraud or misrepresentation, such a claim would require her to allege that she somehow justifiably relied upon the alleged statements to her detriment, which she did not do. However, nothing in that counterclaim suggests that she was even aware of them, much less relied upon them. Accordingly, there's no allegation that her expectations concerning the coverage provided by New York Marine policy were affected by the alleged statements, which she was evidently neither aware of or relied upon in evaluating and deciding to procure the policy by New York Marine, and the alleged statements are not material or pertinent to her claims in the counterclaim. Finally, given the lack of any plausible connection to the coverage available under the policy or any other actionable claim, the allegations concerning coactions, premiums, and assets set forth in paragraph 16 in the counterclaim cannot have been included for any purpose whatsoever except to improperly place the issue of New York Marine's wealth before the jury. Nasty stuff by Amber. Nasty, nasty stuff. Playing tricks. Conclusion. New York Marine respectfully requests that this court dismiss Amber Heard's amended counterclaim without leave to amend. Alternatively, she should be required to provide a more definite statement concerning the meaning of what on earth she meant when she said unable to fully accept the defense provided by New York Marine, and as to whether any of the defense costs which she incurred were at New York Marine's request. And further, in the alternative, if they're not dismissed without leave to amend, paragraph 7 through 16 relate to marketing statements, and they should be removed and stricken. Okay? So that's the main argument. Now, we're not done yet. There's still more. That's the memorandum. One of the lawyers, James P. Wagner, provided a declaration. It's kind of like an affidavit. Declaration, affidavit, kind of the same thing. This was also attached. This is the same date. It was attached as another document. James Wagner, I hereby declare as follows. We're going to go through this briefly. I promise I don't want to keep you here longer than I have to. I want to get to the meat of the declaration because he has something to say. It's very interesting. So Wagner is a licensed attorney in the state of California. He practices in the United States Court, Central District of California. This is his law firm. This is made in support of the motion that we just read. He says that we do have a correct interpretation of the limits of liability policy that was with the reservation of rights issued by New York Marine on October 1st, 2019. And he has copies. This is in support of the argument because they have to show when did Cameron McEvoy, the McEvoy and Roche attorneys came into the case of the John C. Depp versus Amber Laura Heard, filed on January 4, 2017 in Fairfax County. The appearance that they filed. A true copy is attached. He also got a true copy of the Virginia State's Bar Standing Committee with respect to Opinion 598. He also got a copy of the legal ethics opinion that we just read, number 1536. He also obtained the Virginia Bar Association showing that Cameron McEvoy attorneys are licensed in Virginia, as well as the copy and regulatory filings reflecting New York Marine and General Insurance Company was purchased in a go private transaction on or about August 2021. And then it later merged with another company using the merger agreement. He also got a copy of the Tower Brook Capital Partners and Management showing that it was acquired. They'd acquired New York Marine, as well as a copy of the annual statement of the year end December 31st, 2021, filed by New York Marine. Each of these is, again, a document in support of New York Marine's motion to dismiss Amber Heard's counterclaim, as well as management's decision and analysis, year's end of December 31st, 2021, a true copy of the web search page that no financial reports were provided by New York Marine in 2022, and finally, a true and correct copy of various news reports reflecting the go private nature of the merger and sale of New York Marine. So again, we're not going to go through these one by one, but this is interesting that it's attached to show they're trying to show good faith, good nature. And this is very, very important. So if you want, I will show these on screen individually, one by one. So if you want to go back, pause this video, and actually read them yourself, you're more than welcome to. But we are not going to be going over each and every single one of these individually because they're not so relevant to the case, but they are absolutely relevant for some of you who may be interested in reading these on your own time. So it's not that long at all. I'm just going to go through. So for those of you who later wish to pause this video and review these documents, you're more than welcome to. And then we'll go on to the next document. And of course, this was sent to the other attorneys. All right. So that's the declaration of James Wagner, one of the attorneys. Next. Oops, my bad. I keep doing this. Now, there's also a request for a judicial notice. Now, this is a very long document. This document is about 75 pages. This is the request for a judicial notice by New York Marine that was also filed contemporaneously. I believe this is either the last one, the last document, or the next to last document. It's the last document. It's the last document with respect to New York Marine's motion to dismiss Amber Heard's counterclaim. Filed concurrently with the notice motion, memorandum of points, and the declaration and the proposed order. So again, they're asking the court to take judicial notice of copies of documents filed in the action of John C. Depp versus Amber Laura Heard. Sound familiar? Virginia court case number such and such. Same, basically all the documents of James Wagner. 1, 2, 3, 4, 5. This is what we just went over. 6, 7, 8, 9, 10, 11, 12, and 13. So we got that. Here's the agreed order in Johnny Depp's case. They're asking the court to take judicial notice of. Each of these is going to be in support of their claim. There's the legal ethics opinion 598 that we just discussed. Conflict of interest legal ethics opinion 1536. Virginia lawyer directory showing Cameron McEvoy are licensed in Virginia State Bar. All the lawyers, one by one. They're asking the court to recognize and accept this um, and take judicial notice of these facts because that supports their argument. That's Edward Cameron. There's Timothy McEvoy, Sean Roche, or Roche. I'm sure I'm mispronouncing his name. Matthew H. Sorensen, Patrick McDonald, Daniel Ingersoll, Eric Waldman, Richard Cole, William Evans, John Deeden, and the SEC filing about the merger, how New York Marine was merging with ProSite Global. This is all just legal mumbo jumbo. You don't even need to read that. It's boring stuff. Same with this. This is just a merger of the companies, annual statement that they said they're attaching. Management discussion and analysis. That's boilerplate stuff. You trust me, you don't even need to read that. You're gonna, if you want reading material to fall asleep to, this is the kind of stuff you need to read. So they're just filing all this in support, which is logical. Proof of service that it was sent to opposing counsel. And finally, last but not least, with respect to New York Marine's motion and order, you have to have the actual order itself. On March 13th, 2023, 9 days from the recording of this video, not this coming Monday, but the following Monday, plaintiff and counter-defendant New York Marine and General Insurance Company motion to dismiss the counterclaim pursuant to Rule 12b-6, or alternatively for a more definite statement pursuant to Rule 12e, and the motion to strike certain allegations pursuant to Rule 12f was heard. See, this is an order, so it's in past tense, even though it's in the future. But the judge is going to be signing off on this if the judge rules in New York Marine's favor. So we can read it as will have been heard in courtroom 9D of the United States District Court in the Central District of California before Honorable James Wu. New York Marine filed a request for judicial notice. The court finds there is a basis for granting so, let's say, if the court agrees. Obviously, this is not yet signed by the court. This is just boilerplate language. New York Marine requested all this stuff. The court will agree, blah, blah, blah. Having read it and considered a motion to dismiss in other papers and oral argument on future to be March 13th, we'll incorporate everything by reference, specifically pleadings, evidence that New York Marine is right, blah, 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 let's say, and so on and so forth. Basically, this is, again, their standard motion. New York Marine will have been granted. It's even dated, February, because they forgot to change this to March. So if the judge signed this, New York Marine will win without any editing or additions or so on and so forth. Obviously, the judge has a choice to edit it, and the judge has a choice to just sign it as is. So as you can see, it's a proposed order, right? You see it on the bottom. It's not the order of the court just yet. It's simply a proposed order. Once the judge signs this, it becomes official order in the case. All right, now, let's see. It's 9. I didn't expect it to take this long. I thought it would take like 45 minutes. I have another video that I'm going to make separately. I was going to make it today contemporaneously with this one, but instead, I'm actually going to save it and do it either tomorrow or next week. That is Amber's response. Amber's response to New York Marine's motion to dismiss her counterclaims. We're going to do that in a separate video. So New York Marine said its piece. New York Marine said, look, lady, screw off. Well, a week later, Amber filed this motion. A week later, Amber filed this motion, replying and opposing. This is her opposition. This is her opposition to plaintiff New York Marine's argument. And she said, oh, no, 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 no. My argument stands. Even Bonbon says, why would anybody represent her knowing she does not pay her lawyers? Where is she getting the money to pay the current firm representing her in this? That's a fantastic question. Possibly still Travelers fronting the bill. So this is going to get even more convoluted. Even more convoluted. We're going to cover this in the next video. In the next video, we're going to get two things. In the next video, here's what we're going to cover. Amber's opposition to New York Marine's argument, basically Amber's response. And as a treat, because this was just filed 4 days ago, 5 days ago. Just a few days ago, New York Marine filed a reply to Amber's response. So we're going to do those two videos next in the Amber Heard Johnny Depp saga, or I guess in this case, it would be Amber Heard and her insurance providers saga. I hope you all enjoyed this video. I hope you all learned something. I know it gets very hairy and very convoluted. Somebody says we need a Zinnia fix. You want a Zinnia fix? Before we go, I can give you a Zinnia fix. You guys want to see Zinni? Oh, she was laying so cute. Damn it. Now she woke up. All right. I shouldn't have said her name so many times. Oh, hey, LK Nick. I am still so sorry. What are you sorry for? I will stay off James's channel. Don't stay off James's channel. James is cool. I was just so mad, and it takes a lot to get me mad. Again, I'm so sorry to you, not James and Chad. Please don't ask what happened. If Larry wants to know, I'll explain to him and him only. Oh, my. Oh, no. And by the way, this is not a haircut. This is not a haircut. This is, I gelled my hair. I did not, I have a haircut incoming, but this is no haircut, boys and girls. That's gel. See? It's gel. I just gelled it because it was getting so long. I have a haircut scheduled for Wednesday, I think. I think Wednesday. Wednesday, I'm going to chop this hair off. But until then, we are. She looks so rested. Thank you, JM McGee. LK Nick, if you don't mind, send me a DM on Twitter or on Instagram or something, just so that I can understand what on earth happened, because I'm completely lost. I did notice that, Brendan Wilhelmy. I did notice that. She loves that chair. When I'm not in it, she's always in it. She does have her own chair. Right, Zinni? Tell me if your pets are watching the TV right now. Let me know if your pets are enjoying this view as much as I am. All right, you all. Till next time.